Now, I'd like to welcome to the show Nick Morgan, co-founder and president of the Investor Choice Advocates Network. Welcome to Free the Economy, Nick.
Thank you, Richard. Thanks for having me.
So, to start with, can you tell us how you came to be involved in starting ICANN? And because you've actually been on both sides of these legal issues when it comes to finance and regulation.
Yes, a very long time ago, I was senior trial counsel in the SEC's Enforcement Division. For a much longer time, I have been defending people in SEC matters at a firm that, like a lot of firms, charges a lot of money to defend people. And ICANN came about because my partner and I, also a former SEC trial counsel defending people, noticed a gap in the services being provided to people facing SEC matters. Most people can't afford counsel. Most people don't want to litigate with the SEC for that reason. And as a result, the SEC ends up settling something like 98% of the enforcement actions that it brings, either right away or very shortly thereafter. So we saw that as a problem in and of itself. But that pattern of high settlement rates because no one is willing or able to litigate results in and creates a different problem, which is the accumulation of what the SEC views to be precedent case of it's not precedent, but in the SEC's view, these wins, one win after another accumulating suggests a growing jurisdiction for the SEC, growing authority for the SEC. And we thought that pattern came about because of the first problem I described. So we wanted to create ICANN to provide pro bono legal counsel in SEC matters that were capable of setting a so-called precedent so that we could push back and keep the SEC within its proper, much restrained limits.
Nice. Now, so the idea of providing pro bono legal protection to people who are tangling with the Securities and Exchange Commission I think is interesting because a lot of people imagine, if they in their mind they think of someone the SEC is going after, they think of Michael Milken or the movie Wall Street, some Titan billionaire in a fancy office with a dozen expensive lawyers all huddled around his conference table, and that is. As you pointed out, not always the case. And
Right.
and looking at, I think if you look at ICANN's value statement, on the website, I noticed with something that I thought was particularly interesting. So one of the items on here says that capital markets, quote, they're having access to capital markets is essential to helping empower underrepresented populations and to close historic wealth gaps that have too often been exacerbated by excessive government regulation. So that's probably, I would guess, not an intuitive connection for a lot of people. Again, who assume that investing in the stock market is something for people who are already wealthy.
Right.
Can you talk more about that access, the idea that access to capital markets is important for people from non-privileged backgrounds?
Right. So the capital markets broadly encompass what a lot of people think of the stock market. You go to your Schwab, your E-Trade account, you can buy and sell stocks, but it also encompasses a very large private market of securities that are bought and sold. By and large, most people, if they have any interaction, most normal everyday people, if they have any interaction with the stock market at all, it's through their Schwab or E-Trade account, and they believe that's the stock market, the securities and capital markets. In fact, most people are unaware of the fact that there is a much larger capital market that's out there. And the people who are aware of that and take advantage of the opportunities there, by and large, tend to be people who went to elite schools, worked in an investment bank at some point in their career. They're in the industry, if they're individuals at all. And to the extent they're institutions, they tend to be pretty well-heeled institutions, hedge funds, private equity funds, venture capital funds. Um, those people, who sometimes include billionaires and centimillionaires, are fully capable of defending themselves and hiring lawyers. I think for the rest of us, the idea that we might get involved in the capital markets is intimidating. And then if you put on top of that just lack of familiarity, which is really an education problem, you layer on top of that the SEC's expanded authority and its ability to go after people from very minor infractions, would, I think, serve to terrify ordinary people from wanting anything to do with the capital markets. And so we're picking clients very strategically, who because I think another thing that people assume when you hear the SEC sued someone is that they ripped off investors, they stole money, they committed fraud. And many, many, many SEC cases have nothing to do with that. So we pick clients who are not able to afford counsel, so they're sort of ordinary economic means, and they're not accused of fraud or of stealing money from investors. There's some technical issue involved that would result in the SEC's jurisdictional authority expanding in some way. Um, so I think in terms of getting access to the capital markets or even thinking about trying to access the capital markets, people who come from communities that historically aren't part of those capital markets, I think the SEC intimidation factor is likely to chill them or intimidate them even further from wanting to get involved. And I can give some specific examples, but that's kind of in a big picture, um, what we're talking about.
Well, yeah, also, I mean, the all of the like investment opportunities that are outside of the public markets, those, those stock ticker companies you see on a CNBC screen. My colleague John Berlau has written about this, saying that there are, regulations that restrict ordinary people from investing in certain opportunities out there. And so most people really only have the chance to invest in something, make money off something once it becomes a publicly traded company.
Right.
And if either the SEC rules are keeping you from investing in stuff that's not publicly traded, or because it's so complicated, companies don't want to go public in the first place, then
Right.
you don't get the chance to profit off of that, those like big explosive, growth companies that only the sort of kind of professional investor class even has access to them at all.
Exactly. It's um, sort of by the time a stock gets listed on a stock exchange and is available to retail investors, much of the value that is created from a nothing startup to an operating company, much of that value has already been captured by the people who already invested at earlier stages before it became available on our, E-Trade screen.
So, you mentioned that a lot of, or a huge percentage of these cases SEC brings ended up being settled without going actually through the process of a trial, because again, people who aren't already wealthy are kind of intimidated by the cost of that, and they know it might not be possible for them to like carry it all the way through, and that's similarly a criticism that we've heard from a lot of our friends in the criminal law realm, which is that a lot of people are arguably intimidated into settling, without a trial, for other alleged offenses. So that due process is something that is a big source of contention and proposals for reform from some people, both for that, people accused of robbing a store as well as people accused of violating the securities law. So I thought it was interesting that you testified in Congress, the House Financial Services Committee this summer, part of a hearing called SEC Enforcement: Balancing Deterrence and Due Process. And so there's a quotation here that I thought was interesting, summary of that maybe needs to be sort of like unspooled a little. So that was: more due process doesn't have to translate into less deterrence, but less due process surely deters small investors and entrepreneurs from accessing the capital markets. Tell, give us dig into that for us.
Yeah, so that's specifically related to the SEC and other federal agencies has a whole judicial system outside of the federal court system
Mhm.
that is administrative proceedings. These administrative proceedings look a lot like a court proceeding, but they lack many of the due process guarantees that we get in a federal court proceeding. So, for example, the proceedings up until recently were presided over by an administrative law judge. This is an SEC employee who answers to the SEC, who only hears SEC cases. And the administrative proceedings are not governed by the rules that restrict what lawyers can do in federal court. So rules of evidence don't apply, the rules of discovery don't apply. So there are a lot of ways in which the proceedings just don't look anything like a federal court proceeding. And of course, one of the big differences was the subject of a Supreme Court decision in the last term in the SEC versus Jarkissi case, which is in an administrative proceeding, you don't get access to a jury.
Mm.
And so this is very typical of the way the SEC operates. The SEC can go for decades working under the assumption that something that it does is perfectly legal, perfectly constitutional, only to have the Supreme Court tell it otherwise. And so this is what was the case with administrative proceedings and access to a jury. In the Jharkhasi case decided last June, the Supreme Court said people who are accused of fraud, where the SEC is seeking a monetary penalty, are entitled to a jury, which means going to federal court, not using this other administrative proceeding. So, getting back to the quote you mentioned, does giving someone access to a jury, in other words, giving them due process, is that providing less of a deterrence against bad behavior? No, people still lose in front of juries.
Mm.
But it gives them the option to plead their case to a group of their peers, as opposed to an employee administrative law judge at the SEC. So that was one example, this right to a jury, where the SEC didn't lose any deterrence. All it lost was the ability to subject people to an unfair process. And I don't think it's going to have any impact on the deterrence to people who might be inclined to violate the law.
Yeah, I think that's something that probably would come to a surprise to a lot of people when they think about how legal processes are supposed to work. You know, they think of what we call Article 3 courts, the sort of the official courts that are part of our federal system. And, you know, the idea that it's, you know, the SEC versus you and the judge deciding the case is an employee of the SEC. You know, like if you had a workplace complaint against your employer and it turns out the judge was your boss,
Right.
that would be a little
It's
strange.
problematic.
Um,
And it's actually, sorry to interrupt, but it's actually worse than that because in the SEC administrative proceeding context, if the judge rules against you, which was by and large what the administrative law judges did, they almost always found in favor of the SEC, you can appeal that ALJ decision to the SEC. That's your appeal is to the five commissioners sitting in Washington, who employ the ALJ. So the process is, I mean, I think you're right. Like ordinary people, when you describe the process to them, say that really that's your due process. It's not very encouraging.
well, the other thing about one, it's sort of it seems a sort of a questionable premise in the first place, but I feel like some of the defenses of it are also sort of weak. You know, because you know, one thing I've heard say, like people have said, well, if you have these, you know, independent agencies like the SEC and they process all of these kind of administrative cases in-house, and if the agency had to go through a traditional court procedure, it would be too expensive and take too long, and there would be a big backlog of cases, and so the argument seems to be, well, respecting people's due process rights under the Bill of Rights, under the Constitution, would be too complicated and cost too much. So we just won't do it. Right. Well, that wouldn't, you know, that's not a defense you would use for any other constitutional right or any other, you know, expectation of due process.
Right.
Um,
And in fact, it's not true. So, first of all, the sort of argument that SEC AL judges have some particular expertise. Article 3 federal court judges deal with very complex issues, including securities issues, both private and governmental, all the time, as do juries. And it doesn't, when the SEC, in fact, in many cases, the SEC itself will demand access to a jury because it thinks it has a better case in front of a jury. So the idea that only an ALJ could do this efficiently is just not the case. Also, there aren't that many contested administrative proceedings to begin with. I mean, you can go look; they're all on the SEC's website. The open administrative proceedings, there are in any given year a few dozen. We're not talking about thousands. We're not talking about even hundreds. It's a few dozen cases. So, but for those dozen people, it's incredibly important to have access to due process. For the SEC, they can bring it in federal court. It's just not that big of a burden.
so, so let's take a look at a couple of the few of the cases here, see how this sort of dynamic works out in particular details. So you have the case of SEC versus Punch TV, and the summary of that on on the website, which I thought was very a compelling statement, is that it was, quote, a frightening example of how easily a small entrepreneur can find themselves tangled up in the regulatory labyrinth of an activist SEC. What is it that happened in that case?
So our client, Joseph Collins, Black businessman in Los Angeles, who was trying to raise money to create a company called Punch TV that would create streaming content for urban audiences to be sold online. So when he started out, there was a new way to raise money through offering securities that came about as a result of the Jobs Act, which was a bipartisan piece of legislation signed into law by President Obama that was meant to make it easier for people like Joseph to raise money. So it's called he did a Reg A offering. Reg A offering requires you to have a CPA audit your financials. So Joseph goes, hires a CPA, audits the financials. He submits his application to the SEC. The SEC approves the offering. It was one of the very first Reg A offerings. SEC looks at it, approves it. He goes out and raises money. Raised about a little over $1 million. His CPA then comes back to him and says, "Oh, I'm not actually a CPA. Contrary to what you thought, I'm not a CPA." So Joseph does the right thing, reports this to the SEC. And I'll skip over the middle discussion parts, but rather than having him agree to a settlement in which he offered a rescission to the shareholders, the people who bought securities, who by and large were in the Black community in Los Angeles, the SEC sued him in federal court. And the SEC sued him and asked the court to order him to pay back all of the money that he had received from investors, despite the fact that they asserted no fraud claims against him and that they acknowledged that he had already spent most of that money in ways that were consistent with what he said he was going to do. In other words, building this Punch TV case. So he hired a lawyer. The lawyer represented him in federal court for some number of months, and then, like a lot of people who were facing the same circumstances, he ran out of money. And so for some period of months, he had no lawyer, and the SEC filed what's called a summary judgment motion. He was unable to file an opposition, so the judge found in favor of the SEC, saying that he violated the securities registration provisions in the way he went about raising this money. And then the next motion the SEC filed was for the final order in the case where the issue of money was going to be decided. And the question was, how much money should Joseph and Punch TV have to pay back? Well, we have to rewind a few years to a Supreme Court case, Liu v. SEC, where the Supreme Court told the SEC, you cannot get what's called disgorgement, where you force the defendant to pay back money they received. You cannot get disgorgement unless there are victims, and and you can only get it when there are victims to the extent of the net profits, the net proceeds the person received. That is, you deduct out expenses. So in its motion to the court, the SEC ignored that limitation from the Supreme Court and said, hey, Joseph and Punch TV should disgorge every penny of every dollar they received from investors. No offsetting of expenses. And by the way, the SEC did this despite the fact that they never alleged any harm by investors. So we've got no victims, and they want all the money, just completely disregarding the Supreme Court case. So they've got this motion that's all teed up and ready to go. Joseph has no lawyer, and the judge sort of bent over backwards to tell Joseph and Punch TV, look, you're going to have to get a lawyer, or I'm going to rule on this last motion in the case based on what the SEC has told me and without any input from you. And so we found out about the case at ICANN, and we made an appearance, like literally like New Year's Eve, of the deadline the judge had set for a lawyer to make appearance. We filed an opposition. We had a hearing, and I'm happy to report that a week or two ago, the judge ruled in our favor and said that Joseph and Punch TV, rather than paying back $1.35 million in disgorgement and prejudgment interest, and relying on the Supreme Court case of Liu v. SEC, had to pay back $0, which is exactly the right outcome. Here's a person who, trying to do the things right. The SEC in other similar contexts settles these matters in other ways. The SEC ignoring Supreme Court precedent. So we were able to stand up for Joseph and Punch TV in a way that we think is meaningful, not just for him, but for other people who might be considering doing one of these Reg A offerings. If there's some technical violation in the way you do it, does that mean you, at the end of the day, are going to be sued by the SEC and have these enormous financially devastating judgments hung on you? The answer should be no. That's not the way this should work. And so that was a case that recently came to what we think is a conclusion, unless the SEC appeals, which we'd be delighted if they appealed.
Well, that you know, I think that case is, compelling for a number of reasons, but especially because of the sort of voluntary disclosure on the part of the person who said, "Oh, well, I just realized that we've inadvertently violated sort of the rule in this one specific way.
Right.
Um, well, let's do the right thing and make sure the SEC knows we're trying to fix it." And then to get turned around and sued over it, that in that case, I think seems um again to like a non-SEC, not a non-securities attorney
Right.
seems sort of it's really excessive. Like aren't there worse cases out there that they could be working on than one like this?
Right.
Um, so let's keep going. I think there's another one here, SEC versus Barry. And again, the sort of summary here is that it's a story of three Americans whose lives were destroyed after they inadvertently ran afoul of the SEC while simply doing their jobs. What
Right.
was the controversy there?
So I'm going to go back a little bit for context. 30 years ago, so there's a financial instrument that's at the heart of this case, and it's called life settlement arrangements. So this is a investment, and the question is whether it is a security or not. That's the heart of the crux of the matter here. If it's a security, then the SEC has jurisdiction. If it's not a security, no jurisdiction. Pretty binary question. So 30 years ago in the 1990s, this same issue came up, same financial instrument at the time, relatively new instrument, but and the SEC brought a case against someone unrelated to this case. Um, the issue ended up going to the DC Court of Appeals. So this is the federal appellate court that is in the same town as the SEC headquarters. And the DC Court of Appeals said, no, this financial instrument is not a security. You don't have jurisdiction, SEC. SEC asked the court to reconsider, and the court issued a second opinion and said, no, we really mean it. You really don't have jurisdiction over this. For the SEC, that's not the end of the story. The SEC did not feel bound by an appellate court decision from its own circuit. So the SEC continued to bring cases where it asserted jurisdiction over the same instrument, including in 2015, the lawsuit that involved our clients. Our clients were frontline salespeople. They had no managerial role. The company they worked for was selling these life settlement arrangements.
So this is
The
something that would be like an insurance type product, right?
It is an insurance. So it is at its base, there's a life insurance policy at issue. So you take out a life insurance policy, you pay the premiums on it. At some point, you decide you don't want to keep paying the premiums and you'd like to sell your policy. So you can sell, in some circumstances, you can sell your policy to a buyer. And what the company was doing and what the circumstances are in life settlement arrangements is you can then seek investors to help purchase this life insurance policy from the insured. And so that's a life settlement arrangement. Then the purchaser takes over responsibility for paying the premiums. And when the person dies, the investors in the policy either make money if the proceeds exceed the premiums, or they lose money if the proceeds are less than the premiums. But that's the underlying product. So at heart, yes, it's an insurance product. So our three clients were working, selling these things and to investors, and the company they worked for did not consider them to be securities. And based on advice from counsel, presumably that counsel looked at that case I described from the 1990s and said, yeah, well, it's not a security. Um, Nevertheless, nevertheless, the SEC came in, filed a big lawsuit against the company that was selling them, the senior management of the company, and brought in our three clients who had, no reason to believe they were violating the law, but they sued them for unregistered sale of securities. And because the SEC took a position these were securities, they took a position that our three clients needed to be registered as securities brokers. So that's the case against our clients is, and they made commissions off selling these things. And our position is, and what we've argued, and the case is up on appeal, at a fundamental level, the SEC doesn't have jurisdiction here. Now, there were other cases when the SEC went after that 1990s case and continued litigating around the country. There are other cases where courts went the other way. So we have what's called a split of authority among the circuits. The appellate court circuit we're sitting in, the Ninth Circuit, has not yet ruled squarely on this issue, although we think the precedents say they should rule in our favor. So that appeal of that fundamental issue of whether the SEC has jurisdiction is pending in our case. There's another aspect to the case that has to do with whether the SEC is entitled to disgorgement, the issue we talked about with regard to Punch TV. So the appeal is fully briefed. Oral arguments are in December, and I don't know which way the Ninth Circuit is going to go, but I predict, because it is such a fundamental binary issue, does the SEC have jurisdiction or not, that one side or the other probably will appeal whatever the Ninth Circuit decision is.
All right. Well, I mean, that's definitely one to watch there. So, when it comes to some of these, I mean, we could go through you got more cases
Right.
here, we could go through more, but there seems to be a fair amount of sort of overreach and the agency making some fairly unreasonable arguments. Where do you think all of this comes from? Is it just that the SEC, they make some good calls, they make some bad calls, and these are just the bad ones? Is there a sort of motivation for them to overreach? Is it hubris? Like where is all this stuff coming from?
Right. Well, having spent a fair amount of time there, I think it's fair to say, take sort of one argument that people often posit, which is it's because of who's the chair of the SEC. That's why we're having these problems. And I would say, I would disagree with that and say the chair of the SEC can certainly, this is the tone at the top argument the SEC likes to make against defendants. The tone at the top certainly matters. The chair of the SEC can direct rulemaking. The chair of the SEC can, in some ways, direct the resources in one way or another. But by and large, who is the chair of the SEC is not what is causing this problem. This is a more institutional problem that doesn't change from administration to administration, from chair to chair. Regardless of what happens in November, we're going to be facing the same problem. And so the problem really is that there is no brake pedal within the SEC to say, oh, wait a minute, this really goes too far. I mean, there should be. There's an Office of General Counsel, but by and large, if you are the person who raises their hand to say, maybe this is overreach, you're generally viewed as not being aggressive enough. And if you're not being aggressive enough, then that must mean that you're willing to accept people being subjected to fraud and terrible things. So there's not a strong voice within the agency to say, take the jury right issue, to say, oh, maybe there is a right to a jury when we're suing for fraud and looking for penalties. There is no voice. So what ends up happening is you have these cases where there's an incremental change or even a big change in policy. And it's either, well, take, for example, the case we were just talking about with the life settlement policies. When the next case got brought against someone and they're asserting jurisdiction over that financial instrument, who was it at the agency who said, well, wait a minute, the DC Circuit Court of Appeals just told us we don't have jurisdiction. Like, why are we, there isn't someone there to do that. So what ends up
Mhm.
happening is either the people settle or they litigate. But that's how the issues about the expanding jurisdiction or authority of the SEC get decided. They get decided on a case by case, litigation by litigation basis.
So yeah, I mean that sort of preempts my next question, which is going to be about is it about the leadership and who's the chairman, or about like longer term incentives? So if you were going to say, well, how do we fix this problem? You presumably need an SEC that has some discretion, right, to pick and choose cases and decide, without some other grand inquisitors sort of like looking over their shoulder every day. But you also want not to have abuses. So, um, is this something Congress could do, or like amending the 33, 34 acts, the laws that created the SEC,
Right.
um, or s- you know, s- something else about um, the structure of the judiciary? Is the Jarkissi case going to solve some of this, saying that, we were going to let people have their cases in front of a jury, not just in front of the, ACC administrative law judge? What's the thing that's going to do solve the most of this problem without doing other collateral damage?
Right. So I think it's a multi-pronged response. There have been efforts legislatively to curb the SEC's authority in ways that would not harm its mission. I can think of one example. I think it was included in Dodd-Frank, but there's an internal process when the SEC is about to sue someone. They give them what's called a Wells notice. So it's essentially a letter that says, "Hey, we the enforcement staff are about to recommend to the five commissioners that you get sued, and here's why we think that's the case." So that's a Wells notice. So there was a provision that required the SEC. One of the complaints many people have about the process is that the investigations that happen before litigation can go on for years. And so this provision tried to trim that in some way to say that once the SEC gives a Wells notice, the SEC must either bring a lawsuit or close the investigation within 180 days. That seemed like a sensible, I mean, fairly mild, because by the time you give a Wells notice, theoretically, the enforcement division is done with their investigation. That should be the time when they're sort of wrapping up. I can say that provision, that was a statutory provision, has been completely gutted through loopholes and mechanisms because I think Congress didn't want to tie the SEC down too much. So this 180-day period can be extended, which it routinely is. The SEC stopped giving formal Wells notices as early as before, so they would have this, what they currently do this is sort of a informal, well, we're not giving you a Wells notice, but let us tell you why we think we're going to sue you. So sort of an informal Wells process. I'm citing that example as an attempt at legislation to curb some of the abuse here. So I think it's possible. I think you could probably find ways to do that. I do. So that's one prong in the multi-pronged approach. I do think one prong is I can. I think that you just have to litigate more cases. And I think you pick the worst abuse cases where people can't afford counsel. I mean, if you've got someone like Mark Cuban who gets accused of insider trading on an aggressive theory, I feel bad for him, but he had to spend 14, $15 million to go through a jury trial and win. So for those people, God bless and good luck. But I think that litigation, unfortunately, is one of the answers. And the Jarkissi decision, George Jarkissi, I think it took him like 15 years to get to the Supreme Court. So it's an expensive path, but Supreme Court decisions, and there have been multiple in the last 5 to 10 years, do have a lasting impact on the SEC. So litigation is another path. There are also, I think, and this is something that a different chair of the SEC could try and implement. So this Wells process that I mentioned, as the SEC finishes an investigation, what happens is the enforcement staff that investigates puts together an internal recommendation memo to the five commissioners saying, here's what we found and here's what we think we should do about it. And that includes we should file a lawsuit in federal court and it should include these violations for these facts. And then the staff presents that in a closed meeting where the defendants are not permitted to speak or they're not even present. And they don't have any input other than their Wells notice. And then the commission listens to the staff, they ask questions, and then the five commissioners vote on whether or not to proceed with this recommendation to file a lawsuit. That process could use like a red team or I understand why you would not want defense counsel present for that internal recommendation process, the deliberative process by the body. But there's no one in there, or by and large, you might have a rogue staff member, but by and large, all the incentives are to approve those recommendations. And the percentage of recommendation memos that are approved by the commission is approaching 100%. I mean, there are very rare instances where they don't get approved. There needs to be a voice in that process. The SEC should want a voice in that process to say, here are the shortcomings. Oh, there was a DC Circuit Court of Appeals opinion that said we don't have jurisdiction here. Oh, maybe this person is entitled to a jury. There's no one who has that role, and the SEC should want that role so that it doesn't have to waste resources losing in the Supreme Court again.
Well, yeah, it seems like this could be sort of the like college debater role where you're just, maybe you work at the SEC, but you're just assigned to be the argue against this recommendation.
The devil's advocate, right?
Yeah.
Yeah, yeah. I mean, and that role, if it existed, which it doesn't, could be co-opted and could, hey, you're always interfering with our, but it's something the SEC should consider doing so that it's not just a rubber stamp process, so that there's some critical voice in there saying maybe this is a step too far.
Nice. And so the uh that sort of, multi-pronged strategy is, it's not something where you just say, well, Congress needs to fix the SEC bill and then everything will be fixed, right? So
Right.
it's this sort of long going, it's just sort of like what, the Competitive Enterprise Institute does, which is, comments on all these rulemakings and, writes and does research and stuff about it. The goal is not that like it's gonna be fixed and then we can go on, we can like retire to our private islands.
Right.
It's this sort of, in politics, there are no permanent victories, and fortunately, the corollary is there are no permanent losses either,
Right.
and it requires a kind of informed, motivated, and funded group of people to go out there and just be engaging all the sort of this push and pull between um, policymakers who have their own institutional incentives, and then people who like us, I think, who need to be on the other side of that, pushing back on some of these cases of overreach. And which brings me to an important point. I noticed that ICANN is a finalist for an important prize, the Peterson Prize in Venture Philanthropy, and so that's awarded for trailblazing startups in the nonprofit sector. Can you just tell us quickly about what that's all about
Yeah.
and why you guys are on that short list?
So Greg Peterson, who the prize is named after, and I started it, was an early venture capitalist. My understanding is he started the first VC, or one, I should say, the first, one of the early VC funds on the West Coast, out in the Bay Area. And so now the prize is given annually. And we thought we were a good fit for the prize because of the origins of the prize and the fact that it relates to sort of venture capital, but they also are looking for, I think, entrepreneurial thinking. We hope that we are bringing an entrepreneurial aspect to this. We also think that we are helping entrepreneurs, actual entrepreneurs out in the marketplace who would like to be able to access capital, or help the capital formation process be more smooth and easy to access. So we hoped we were a good candidate for it, and we applied some months back. And yeah, we were excited to find out that we were one of the 6 finalists. And so keeping our fingers crossed for the decision in December.
All right. Well, congratulations.
Thank you.
And thanks for being with us today, Nick. This has been an
Pleasure.
excellent conversation. Before we go, tell us about where can we find you? Are you on social media? Where do we find ICANN, all that stuff?
Yeah, easiest place is icanlaw.org. That's our website. We're also pretty active on LinkedIn, have a Twitter handle, but the website is probably the easiest place to go. You can find those other things from there.
Yeah, I'm sure there's a donate button on there somewhere on that website too.
Indeed, there is. Yes, thanks for reminding me. There is, in fact, a donate button. And anybody who wants to reach out on that or any other issue, we love to hear feedback.
All right. Thanks again, Nick.
Thank you.